Take a look at this. Judge Analisa Torres, the judge who gave Ripple and XRP hope. In July of last year, federal judge Analisa Torres granted Ripple an interim victory in its battle against the United States Securities and Exchange Commission, which was a boon for the cryptocurrency industry. Judge Torres determined that although Ripple broke federal securities laws by selling XRP to institutions directly, the company did not break the law by selling XRP to regular customers through exchanges. When it comes to the specific application of federal securities rules to digital assets, the crypto sector and the SEC couldn't be more different. Judgment on the validity of the SEC's interpretation and the validity of companies' claims that existing laws are irrelevant and out of date has fallen on the United States judiciary system due to the lack of legislation from Congress that could establish so-called bright lines guidance, establish an exemption for token companies and trading platforms. This isn't merely a theoretical concern. Crypto firms argue that the inherent decentralized and disintermediated nature of digital asset issuers makes compliance with the stringent disclosure and registration requirements that apply to assets classified as securities impossible. Just like their conventional financial sector equivalents, trading platforms that list such assets are also subject to a stringent regulatory framework. Everything is much simpler for these businesses if an asset is not considered a security. This is an especially important question in light of the fact that the SEC has filed multiple lawsuits in the district court for the Southern District of New York and is presently managing about a dozen cryptocurrency concerns. It is possible that the industry will often refer back to Judge Torres' decision that Ripple lawfully sold and was permitted to sell XRP to retail investors through blind bid hack sales on exchanges. Most people who bought XRP on cryptocurrency exchanges didn't put their money into Ripple in any way. Although an institutional buyer knew exactly what it was getting when it bought XRP from Ripple through the official channel of a contract, a programmatic buyer was just as naive as a secondary market buyer when it came to the economics of the situation. The verdict rocked the business world, but many wondered what kind of precedent it really established. The decision was undoubtedly extremely helpful for exchanges in particular, according to crypto client attorney Grant Glovson. However, the verdict's potential positive impact on cryptocurrency businesses and initiatives really depends. At this time, the decision is just being considered in one courtroom, but it will certainly be appealed by the SEC once the case as a whole is finalized. It appears that the regulator is trying to speed up the appeal process by dropping accusations involving Ripple executives Brad Garlinghouse and Chris Larson. If the ruling gets accepted by the Court of Appeals, it theoretically offers a pathway for projects to raise funds, said Gulivson. The decision of Judge Torres could potentially turn out to be unusual. Judge Jed Rakoff, who is also a member of this court, also rejected Judge Torres' analysis in his summary judgment decision in the SEC's case against Terraform Labs. However, the specifics of that ruling are case-specific, just as the specifics of the Ripple ruling are case-specific. Federal Judge Analisa Torres, who in July of last year granted Ripple and XRP a partial success in their struggle with the United States Securities and Exchange Commission, boosted the cryptocurrency industry. The industry made great strides forward with this triumph. Although selling XRP to individual and institutional clients violated federal securities law, Judge Torres found that normal users could not obtain XRP from exchanges because Ripple had breached the law. Included in CoinDesk's list of among the most significant 2023 profiles is this one. Exactly how digital assets should be governed by federal securities laws is a point of contention between the Bitcoin industry and the Securities and Exchange Commission. Since Congress has failed to pass any legislation to create so-called bright lines guidance or a buffer zone for token sellers and trading platforms, the U.S. judicial system has been left to decide if the SEC's explanation is correct or if businesses have a valid point in claiming that the laws as there are inappropriate and outdated. The question of AZN goes beyond the realm of academia. In the US, issuers are subject to strict disclosure and registration requirements if their assets are deemed securities. The cryptocurrency industry claims that these regulations are unworkable due to the disintermediated and decentralized nature of digital asset tokens. The regulatory structure that controls traditional financial platforms is very similar to the one that governs trading platforms that list these assets. Everything is also much easier for these companies if an asset is not deemed a security. Where this matter is more pressing than anywhere else is in the federal court for the Southern District of New York, which is currently overseeing about a dozen crypto actions, including multiple claims filed by the Securities and Exchange Commission. Since Judge Torres' decision upheld Ripple's right to sell XRP to retail investors and allows them to do so via blind bid hex sales on exchanges. This ruling could set a precedent that the industry regularly uses. It was impossible for programmatic purchasers to tell if their XRP payments went to Ripple or another vendor. The vast majority of people who purchased XRP from cryptocurrency exchanges did not put their money into Ripple in any manner, as the judge pointed out in his ruling. Despite the fact that a large buyer contracted with Ripple to buy XRP in advance, when it came to the numbers, a programmatic buyer was no different from a secondary market buyer in that it had no idea who or what it was paying. The judgment sent shockwaves across the company and raised concerns about the precedent it set, to name one example. According to Grant Glubson, an attorney who represents customers in the Bitcoin business, the ruling was clearly advantageous for exchanges in particular. However, the decision's potential positive impact on cryptocurrency firms and activities is highly subjective. The decision is being handed down in one courtroom within one court, and it's clear that the SEC plans on appealing it once the case is done, with what seems like an attempt to speed up the appeals process. The claims made against Brad Garlinghouse and Chris Larson, two executives of Ripple, have previously been dismissed by the regulatory authority. A possible avenue for projects to garner cash, gloves, and explanations to media could open up if the Court of Appeals rules in favor of the plaintiffs. On top of that, Judge Torres' ruling could end up being strange. Judge Jed Rakoff, a fellow judge on the same court, summarily rejected Judge Torres' analysis in the SEC's lawsuit against Terraform Labs. Just as this case's specific facts are different from the Ripple verdict, so too are the specific circumstances surrounding that decision. The Court of Appeals' decision may not be forthcoming for some time. In Ripple's continuing legal struggle with the Securities and Exchange Commission, CEO Brad Garlinghouse has hinted at a major overhaul. He hinted at a potential confrontation, which sparked speculation about a possible settlement or major conclusion. Nearly instantly after this tweet went out, those specializing in cryptocurrency law chimed in. According to crypto law expert Bill Morgan, the excitement is all just rubbish. He claims that a settlement meeting signifies the end of the legal battle. An epic showdown is not the same as a settlement. He says taking his time to make that point clear. Reason being, it necessitates giving a little and finding common ground on some issues. Considering the available options and the challenges that need to be addressed, Morgan believes that a settlement is now unlikely. He raises the potentially very worrisome fact that in most cases, disputes are settled through settlements, which provide the chance to appeal. What is currently under consideration may not represent the full extent of the real implications of a settlement. Be advised that the data shown here should not be construed as a trading recommendation. You should not put your money into anything that relies on the data presented here. We highly recommend doing your own research and talking with an experienced expert before making any investment-related decisions.